the detailed discussions. So my job is just to welcome you to the second session, and in due course, the lineup of activities and the speeches will be adhered to, especially the time aspect of it, so that we don't spend too much time. Thank you.
Thank you very much. Shall we now have Justice Dennis to deliver his part of the job, and we'll be all empowered. I know that for sure.
Thank you, Chairman, for this occasion. My laws, Nananom, and I may be permitted to stand by the existing protocols because the break was less than 20 minutes. Then I may be permitted to stand by the existing protocols. The Land Act 2020, that is Act 1036, as we know, came into force on 23rd December 2020 for several reasons. The first one, to repeal laws on land which had become anachronistic and further consolidate and revise the existing laws on land law to ensure that land tenure in Ghana is administered and managed effectively and efficiently. Because we all look at the mischief of every law. So what was the mischief? This is one of the aims seeking to cure the mischief under the existing legislation. The Act further altered some of the customary land law and common law principles and land tenure, which had become obsolete to meet the needs of the time. Quite often, when we are talking about laws and we mention common law, people ask, you have statutes, why do you talk about common law? Common law continues to form part of our law by virtue of Article 11 of the Constitution. It is part of our law. Then we also talk about some existing laws, which we normally refer to as statutes of general application. Some laws were made for the English people for themselves and their colonies in 1925, and we continue to use some of them. If you look at Section 117 of the Courts Act, it says that those provisions, about 19 provisions, which have not been repealed under the English Land Act of 1925, continue to form part of our law. The Act sought to provide other matters on land to ensure that constitutional provisions on land tenure are given effect to. Third, it was to criminalize acts of people who alienate land, individuals who unlawfully use persons to protect their interests in land, which we normally refer to as land guards. Then persons who allow other persons to unlawfully use them to exercise control over lands. We talk about those who make use of land guards and land guards. It was also aiming at criminalizing some acts of public officers, particularly those who engage in land frauds. Four, the Act is to ensure that persons who trespass onto government or public lands are prosecuted. Even though there was an enactment and it was very, very deterrent enough, the public officers did not take advantage of that provision. So there was the need to consolidate it as part of the Land Act. Then the fifth, to permit an action to be instituted against a trespasser whose identity cannot be ascertained. The position of the law was that if you wanted to sue somebody, the person may be building overnight. You do know the name of the person. You will go and meet some people developing the land. You will ask them, who is the owner? They will tell you, you don't know the owner. And the person will be building day and night. And the laws on the land provided that you cannot bring an action against a person known as trespasser. But this act has now made it permissible for an action to be brought against a person whose identity cannot be ascertained and at the same time seek injunction from the courts. So as you could see, some of the laws, the 13 laws, the Land Development Protection of Purchases Act 1960, Act 2. Act 2 had become anachronistic. What was Act 2? Act 2 was enacted to protect those who have acquired land within 3 miles radius in Accra, where they acquired the land in good faith, by the title was defective and have built up to the lintel level. It is only 3 miles radius in Accra, but people thought it was the whole Ghana. You saw people building, and they were pleading Act 2, even though it was not applicable. Then Farmlands Protection Act 1962, Act 107, Rent Stabilization Act. If you look at all these laws, the Act 2, there was no such land in Accra, within Accra, to be protected, because it did not even extend to Opongru, Legon. They were not part of Accra. Then when you talk about Act 107, it became obsolete after the farmlands in certain parts of the country, where it sought to protect the interests of persons of these people had been fully cultivated. This law was passed that to control people who have acquired land they were not cultivating, and people who have also acquired land and the tenancy agreements were harsh. It was as far back as 1962 and had become obsolete, but it continued to form part of the existing laws. Then we talk about the Land Registry Act. It is still with it needed revision. Administration of Lands Act, we used to have 2 lands regulating acquisition by government. When your land was acquired under the Administration of Lands Act 1, 2, 3, the land was acquired, government paid only the developments on the land, and at the end of every year, government continued to pay rent. But in respect of the State Lands Act, compulsory acquisition, government pays for everything, and you lose whatever interest that you have in the land. Then we have the Public Conveyancing Act, the Conveyancing Act, Public Lands Protection Act 1974. If you look at this law and the rationale behind its enactment, it was very, very useful, except that it became a white elephant. This law was passed in 1974, NRCD 240. It was passed because people were encroaching upon government land, and the law available then was trespass. And trespass, you know, it is misdemeanor. The sentence that you could impose, just about a fine, it could be 50 Ghana cedis, 100 Ghana cedis. So the then government decided to come out with deterrent law to deter people who will encroach on government land, that your structures will be demolished, you will be prosecuted. If you prevented a public officer from abating your nuisance, it was a criminal offense. Then laws on compulsory acquisition, we had all these laws. The presentation will be made under the following thematic areas: changes made to customary land law by Land Act. Customary law is part of our law by virtue of Article 11 of the Constitution. Then changes made to the common law, effect given to constitutional provisions, protection of land by the use of unlawful means, improvements on implied covenants. Implied covenants means that whenever you enter into an agreement, land transaction, whether a lease or whatever, there is the position that some laws are impliedly part of the agreement, so you need not incorporate them in writing. And we have express covenant. So the implied covenants under the old or the repealed Conveyancing Act, NRCD 175, it wasn't helpful. So there was the need. Then how to use the alternative dispute resolution to resolve dispute amicably without resorting to court. Or where the matter is in court, would the judges have the mandate or the authority to refer the matter to arbitration, mediation, customary arbitration for effective resolution timeously. We are now going to look at changes made to the customary law. The Land Act 1036 redefined some of the customary land law principles, such as customary tenancies, which require the tenants to share the proceeds from the farm That is where you give a land to somebody on Abunu or Abusan, meaning you'll be entitled to 1/3 or 2/3. Then the law was that you could share only the proceeds and not the land. But the Land Act has taken a very drastic position on that one in support of the radical decisions by some of the courts that to them it was an agreement and therefore it was unconscionable. When I enter into an agreement with somebody to enter into an abunu that we will share at the end of the day, there shall be severance or physical partition of the farm. Then after maturity, you tell me that we can only share the proceeds from the farm and not the land together with the crops thereon. So some decisions were delivered, and the Land Act took that one into account. And now the position is that it is not limited to the sharing of farm produce. You could share the land, physical partition of the land. It is based on the agreement. Then allodia title holders of lands whose lands were occupied. When we talk about allodia, it is the ultimate interest, the highest interest in land that a person may acquire. We have interest in land, the highest allodia. Then we have the other freeholds. When we talk about freeholds, we call them freeholds because they are not constrained by time, meaning it is perpetual once you are occupying it. So we have allodia, we have customary law freehold, we have common law freehold, we have usufructuary interest. In the case of Boatin number 2 versus Menu number 2, which is reported in 2007-2008 to Supreme Court Ghana Law Report 1117, the question was, when it comes to alienation of land, which had become ousted for public use, ousted land, who should alienate? It traveled from the High Court, Court of Appeal, Supreme Court. And Supreme Court held that it is the person in possession who could alienate and not the allodia owner. But the Act has redefined it, that where there is a land which has fallen into outskirt and it is occupied by an usufruct, and it is needed for the use of the community or for alienation, it is the allodia owner. I will discuss it in detail. When we look at sections 20 and 21 of the Act, which has changed the customary law, land law position, it states as follows, 20, I quote, a holder of usufructuary interest under section 19 shall not alienate any interest in land which is subject of that interest to a person who is not entitled to that interest without the written consent of an adequate payment of the allodia owner, which consent shall not be unreasonably withheld. So now it has recognized the interest of the allodia owner. Then 21, in furtherance of the expansion of a town or settlement for the purpose of serving the community, so where you needed it to serve the community, you needed it for expansion of town. The one I talk about, Boatin number 2 versus Mensa, it was where at Ejoso, the Ejoso mine wanted to allocate some land to Kinfesa to have a sports stadium. Then it traveled, then Supreme Court held that it was wrong for the chief to alienate because those on the land, the usufruct, they were the proper persons who have alienated. But this Land Act has changed the position. The only condition imposed on the allodia title holder who takes over a bare land or farmland of an usufructuary interest within the area covered by the allodia title is mandated to make prompt payment of fair and adequate compensation. You don't deprive the person absolutely. You must make prompt payment of fair and adequate compensation, which shall not be less than 40% of the value of the plots. So you value the plots, how much? If it is 10,000, you shouldn't pay the person less than 40% of the plot. Or where there is a suitable alternative land, you may give it to the person who has been deprived of his interest in land. So the Land Act indeed has modified the customary law principle here to make it acceptable and more beneficial to people of community as well as the allodia owners. Let's look at the effect of Land Act on common law. The common law position regarding capacity to enter into contracts was fixed for 21 years at common law. If you are not 21, you could not deal with land matters. If you were 19, 18, somebody will hold the land in trust for you until you attain 21. Quite often, people were confusing an infant and a child. There's a difference between infant and a child. A child, as defined by the Constitution, is a person under 18 years. Common law, as understood at common law, is a person under 21. So they were not the same. If you look at our rules of courts, the High Court Civil Procedure Rules, the High Court Civil Procedure Rules, that is Order 5 Rule 1, mandates a person of 18 years to bring an action. But the law, the common law is that if you are not of 21, you could not hold interest in land. So if you cannot hold interest in land, can you bring an action to maintain it? There was this conflict, and it needed to be resolved. But the district court rules try to play it safe. It did not mention any age. Now, when you look at the Land Title Registration Act, which has also been repealed by this act, PNDC Law 152, it forbade an infant, a person under 21 years, from maintaining an action in that person's name and also acquiring land in that person's name. So where the substantive law says if you are not of 21, you cannot maintain an action, you cannot acquire. The rules of court, which is subsidiary, says you can. Indeed, the subsidiary legislation was wrong. So the position is, if I'm 18, I can vote. Now, under the Local Governance Act, if I'm 18, I can become an assemblyman. Why is it that if I'm 18, I cannot acquire land? So this one has been settled by the Land Act. Let's look at some of the constitutional provisions. Non-citizens of Ghana cannot acquire interest in land exceeding 50 years at any one time. And the history was that it was in the 1969 Constitution, a committee that drafted the 1969 Constitution. They did consultation and they came to the conclusion that if you look at how Ghanaians were losing their land, there was the need to protect Ghanaians. So if you were not a citizen of Ghana and you had any interest in land, if the interest was freehold on the coming into force of that Constitution on 22nd of August 1969, your interest in the land, even though it was freehold, absolute, automatically it converted from that freehold to 50 years. So all of them lost their interest in last year, that is 21st of August. So you needed to reapply for renewal. So that is the background to that law. But there was a problem. The law, the Constitution says that a non-citizen of Ghana cannot acquire any interest exceeding 50 years at any one time. And there was no definition for a company. So the courts were confused. At times, we may resort to other laws. So when we talk about a company which is a Ghanaian, a company which is not a Ghanaian, how do we address them? But fortunately, Section 1010 of the Land Act has now addressed it. It says that a company or body corporate in which a Ghanaian has 60% or more equity shareholding is a Ghanaian. So now, if you are talking about a company and we have Ghanaians holding more than 60%, then it is a Ghanaian, then it can acquire land in excess of the 50 years. But if it is less than that, it is non-Ghanaian and you cannot acquire. A non-citizen of Ghana who marries a citizen of Ghana may acquire land in that person's capacity as a non-citizen of Ghana. A marriage or partnership entered between a non-citizen of Ghana and a citizen of Ghana shall not be affected by the marriage or the partnership. You cannot use marriage to come and acquire land. If you are a foreigner, non-citizen, you acquire land that are married to a Ghanaian. It doesn't matter. You maintain your interest not exceeding 50 years at any one time. The Constitution recognizes the duty imposed on chiefs, crown heads, tendana, head of families who are managers of land, meant for the people they represent. They stand in fiduciary position and are accountable to their respective stools, skins, clans, and families. Chiefs, clan heads, tendana, and head of families are accountable in respect of lands they stand in fiduciaries where they fail to account. An action may be brought against them in the High Court to compel them to account after all established customary procedures have been exhausted. We used to have only one law, head of family accountability law, that permitted a person to compel a head of family who has failed to account. But now it has been extended to cover chiefs, tendanas, clan heads. And another important milestone this Land Act has introduced was to how it gave effect to Article 36, clauses 8 and 9 of the Constitution. We all know that when we talk about the directive principles of state policy, there was a confusion. Somebody will tell you it is they form part of the Constitution and are therefore justiciable. Another decision will tell you they are not justiciable. Then the final decision now is that they are presumptively justiciable. Where the basic presumptions are met, then you can enforce them. But this Land Act has enacted it to make it binding. The provision reads as follows: the state shall recognize that ownership and possession of land carry a social obligation to serve the larger community, and in particular, the state shall recognize that managers of public, stool, skin, and family lands are fiduciaries charged with obligation to discharge their functions for the benefit, respectively, of the people of Ghana, of the stool, skin, or family concerned, and are accountable as fiduciaries in this regard. Now, this one has been given effect to by the Land Act. It is a great achievement. Now, if they fail to do, let's look at, apart from bringing an action against them, a chief, head of clan, tendana, or head of family in management of stool, skin, clan, tendana, or family lands shall be fair, transparent, and impartial, and shall account as fiduciaries to the persons concerned. And a manager who fails to account in accordance with the law commits an offense, apart from the action that may be brought against you in civil court to compel you to account. Now, you commit an offense, and if you are convicted, you may be sentenced to a fine of not less than 5,000 penalty units, that is 60,000 Ghana cedis, and not more than 10,000 penalty units, that is 120,000 Ghana cedis, or a term of imprisonment of not less than 5 years and not more than 10 years. So where such a person fails to account, and the person is being used as a deterrent and to prevent that person, the minimum sentence the court can give is 5 years, and the maximum is 10. To ensure that land managers appreciate that they are fiduciaries and must be fair and transparent, the Act has made it mandatory for stools, skins, clans, and families with allodial interest in land to register the lands before an alienation of a whole or part of the land can be made. Now, go and register. If you fail to register and you alienate, you commit a criminal offense. If you register, we know the number of pros. So if you are alienating, they are 40, and you account for 10, they can hold you accountable. What about the 30? Because you have registered 40. To ensure that land managers appreciate that they are fiduciaries and must be fair and transparent, the Act now has provided a procedure for registration of those lands, the fiduciaries, to demarcate, survey, and prepare a plan, and the land duly approved by the Director of Mapping and Survey Division of the Lands Commission. That is Section 182 of the Land Act. You must comply with it, else you cannot alienate in your capacity as an allodial owner. A stool, skin, clan, or family which has allodial title to land cannot alienate without the consent and concurrence of the Regional Lands Commission. It wasn't so. It was limited only to stools and skins. But this Act has extended the scope, if you look at Section 182, to cover family and clan lands. If you are alienating, then you require the consent of the Regional Lands Commission. And we know the reason why you required the consent. People may alienate lands without making provision for schools, police station, access. So to abate this, you need the consent. If not, you cannot alienate. It is a unique provision, as the Constitution did not include clan and family lands under the lands which require the consent and concurrence of the Regional Lands Commission. A chief, Tindana, clan head, or head of family who alienates a part of land he holds a allodial title of, without first having it registered, commits an offense, and upon conviction shall be liable to a fine of not less than 5,000 penalty units, that is 60,000 Ghana cedis, and not more than 10,000 penalty units, that is 120,000 Ghana cedis, or to a term of imprisonment of not less than 5 years and not more than 10 years, or to both. Let's look at protection of land and interest in land. We used to have the Criminal Offences Act dealing with trespassing. Trespass, the law permits even just caution, payment of just a little fine, but the position has changed. The Land Act has criminalized the activities of persons who use unlawful means to exercise or supervise or control land development at a place where that person hasn't got any interest in the land, and uses same for extortion or prevents a developer from developing that developer's land. Such a person commits an offense and upon conviction shall be liable to a term of imprisonment of not less than 5 years and not more than 15 years. Indeed, there is an omission in the law, as the fine contained in the bill. In the bill, it made provision for custodial and a fine. But in the Act, it has taken away the fine. There is nothing wrong with it. But if you read the text, you see that there is an omission. It reads as follows. Person commits an offense and is liable on summary conviction to a term of imprisonment of not less than 5 years and not more than 15 years, or to both. To the both, there suggests that there was something which has been omitted. So the activities of land guard, as we normally call, is now criminalized. Additionally, those who use land guards, additionally, a person who uses persons to use force, violence, intimidation to prevent lawful owners of land from developing their lands, commits an offense, and upon conviction shall be liable to a term of imprisonment of not less than 10 years and not more than 15 years. Those who use land guards, the sentence is very, very harsh. Minimum of 10, maximum of 15. And the funny thing is that there is no alternative fine. So if you engage somebody as a land guard and the person is arrested and you are also arrested and you are tried and you are convicted, as at now, there is no option of a fine. In the bill it was, but it has been taken away. The offense committed by such a person who engages a land guard to commit an offense under Section 12 of the Land Act is more serious than a land guard who is convicted of an offense under the Act, because you have engaged the person. If you haven't engaged the person, he wouldn't have done it. An action may be brought against a person who acts contrary to the provisions of Section 12(1)(a) or (b) and (c) of the Land Act, and an injunction may be sought against such a person to restrain the person from unlawfully exercising control or supervision of the land that person hasn't got any interest in it. So now an action could be brought against a land guard in civil. Now let's look at acquisition of land by the state. This is a very important area of the law. You know, ordinarily, states have the power. The states have power to acquire lands because of the eminent domain given to them as a state. So if you have your land and the state shows interest in it for public use, then the law says that the state can acquire it. You cannot resist the state from acquiring it. But quite often, the state will acquire a land from somebody. Then another person will go and occupy the land and take it. You know, basically, it is unconscionable. So let's look at it. The eminent domain exercisable by the state empowers the state to compulsorily acquire the land of whatever kind, where it is necessary in the interest of defense, public safety, public order, public morality, public health, town planning, or for the development of property to promote public benefit irrespective of hardship that the acquisition may occasion to the person with interest in the land. However, subject to prompt payment of adequate and fair compensation. The other grounds which may necessitate the state to compulsorily acquire land includes where the state requires the land for provision of essential services, resettlement, roads, railways, bridges, public utility services, dams, sewage system, pipelines. When the state compulsorily acquires lands in accordance with the Land Act, it shall make prompt payment of fair and adequate compensation, and the person whose land has been acquired shall have access to the High Court for fair and adequate compensation to be assessed. Where it is assessed, you are uncomfortable with it, then you have unfettered access to the High Court, and the High Court shall assess in accordance with law. Traditionally, stools, skins, crowns, families, and individuals were eligible to hold allodial titles, and they acquired them through conquest, historically. Conquest, pioneer discovery and settlement, gifts, agreement, or purchase. So when we talk about the allodial owners, these were the people. We talk about skin, stools, crowns, families, and individuals who acquired them through either conquest, pioneer discovery and settlement, gift, agreement, or purchase. But as a result of compulsory acquisition, now, when we talk about allodial interest, the state is number one, because the state owes about 20% of. So now, if there's two acquires, compulsory acquire a land, the allodial owner, the lesser interest, all of them, they lose their interest, and the state becomes the allodial owner of that land. Public lands which have been acquired by the state by the use of its eminent domain against the wishes of the persons with interest or rights over them are to be used for the purposes for which they were acquired or for public interest. However, persons may unlawfully enter onto them and exercise adverse possession over same. A person who exercises adverse possession over land for 12 years assesses title to the land through adverse possession. We have several decisions that if you are on the land is acquired, you lose every interest in the land. But if you continue to be on the land, or another person comes onto the land, and for 12 years, the person became the owner of the land. We have several cases, Gihok, refrigeration, several of them. So that was the position of the law. And people could also use some of the common law principles, acquiescence, waiver. You are on the land, I'm developing it. You saw me, you did not raise any objection. I've developed it. So if the state brings an action against me, I will plead acquiescence, waiver, estoppel, depending on the nature of defense, common law defense available. The position was that limitation or prescription operates against the state, despite the fact that the Repealed Public Lands Act Protection Act 1974 provided a strict sanction. Because the law says, if you are on the land, prosecute the person. But you do not prosecute the person. The person stays on the land for 12 years. Adverse possession. It matures into interest. The person became owner of the land. So if you are going to prosecute, you are no more the owner. He is the owner. So you could not prosecute him after 12 years. The position was that limitation or prescription operated against the state, despite the fact that the Repealed Public Lands Act provided harsh sentence. The current position is that the Limitation Act, NRCD 54, and any other laws on prescription shall not operate against public lands. So now, if you encroach upon public land, the law says prosecute the person, and you cannot use adverse possession to assert title. So now you cannot take advantage of limitation, adverse possession, prescription to acquire interest in public land which has been compulsorily acquired by the state. Unlawful occupation or sale of public land has been criminalized to deter persons who unlawfully possess public lands for 12 years or more from asserting adverse possession through the Limitation Act. A person who unlawfully alienates public lands commits an offense under the Land Act and shall, upon conviction, be liable to a fine of not less than 5,000 penalty units, 60,000, and not more than 120,000, that is 10,000 penalty units, or to a term of imprisonment of not less than 7 years and not more than 15 years, or to both. So if you sell public lands, the minimum sentence is 5, the minimum is 7, and the maximum is 15. It is also an offense to encroach upon public land, and a person found in possession of public land shall be presumed to have encroached upon it, and the burden shall be on that person to rebut it, that I'm not on it. A person convicted of encroachment of public land shall be liable to a fine of not less than 1,000 penalty units, that is 12,000 Ghana cedis, and not more than 2,000 penalty units, that is 24,000 cedis, or to a term of imprisonment of not less than 1 year and not more than 3 years, or to both. A person who unlawfully occupies public land shall be given 21 days in writing by the appropriate agency to vacate. You know, it was under the old law, NRCD 240, where somebody encroaches upon government land. Serve the person a notice, 21 days, to vacate. If he fails, go and demolish, and no action can be brought against you. And even when an action is brought against you, you pray that it was done in accordance with law and it was made in good faith. That was the provision of that law. Now the question is, why is it that some people took advantage and occupied public lands and were not prosecuted? A person who obstructs an appropriate agency from ejecting an encroacher commits an offense, and upon conviction shall be liable to a fine of not more than 1,000 penalty units, and not more than, that is, and not more than, less than 500, and not more than 1,000, or to a term of imprisonment of not less than 6 months and not more than 12 months, or to both. Electronic conveyancing, it is an innovation. Electronic conveyancing has been introduced to expedite transfer of an interest in land. The Vice President said it. Or right over land. Only qualified licensed legal practitioners may be granted access to provide electronic conveyancing service. The law had been that if you are not a lawyer, you cannot prepare and sign conveyancing. But people do and sign, and they give to some people to sign for them. Now, this bad practice has been taken away with the introduction of the electronic conveyancing, because it is not transferable. Once it is issued in your name, you cannot assign it even to a colleague or partner in your office. A legislative instrument shall be made to prescribe additional requirements for electronic conveyancing. That is where I have my problems. Who is going to manage favoritism? If we do not ensure that it is given to lawyers who qualify and have been issued to, and those who are going to manage, they should ensure that they must act fairly in accordance with the Constitution. It is a discretionary exercise they are going to exercise, and they should not exercise it capriciously or arbitrarily. Offenses for land transaction. Land officers are committed, that is, when we talk about land officer, we talk about land offenses, it includes public officers. So we are talking about managers of land, public officers, persons who unlawfully use force to manage or supervise lands, and persons who make use of them, persons who alienate lands without interest or who had previously divested themselves of their interest in the land. It is a notorious fact that fraudulent transactions at the Lands Commission are committed by land fraudsters with the assistance of some of the public officers with the Commission. Now, if you look at some of the cases that have been in court and others pending, an executive instrument had been issued in the central region for government to acquire land. The land has been given to one of the telecommunications to use. Then the chief brought an action against government. Then the Land Commission filed a defense. Yes, indeed, it is not a vested land. It is not a state land. Meanwhile, it is a state land. Then at the end of the day, the court awarded, they entered into an agreement they valued, and government was to pay $16.1 million, not in cedis. You know, how can a public officer working with the Lands Commission file such a defense? He goes to court, and the person says, yes, it was wrong, it was wrong. Then we come to the Achimota case, the same thing. The Achimota case, the Land Commission, they put up a defense which they admitted everything, which was indeed not true. Then after judgment had been given, to inform Achimota to bring an action timeously, it was 1 year, 7 months that a letter was written to Achimota that your land has been, judgment has been given against you in respect of part of your land. But the lady who wrote the letter did very well, because without her, it wouldn't have come to the notice of Achimota, because the lawyer for the Lands Commission, in his pleadings, admitted everything and submitted to judgment. So at times, when they turn around to blame the court, it is not the court. I'm here as a speaker, and I'm also representing the Judicial Service. The Chief Justice wrote a letter to me too. So I'm here in dual capacity. So now, a public officer convicted of any of the above offenses shall be liable to a fine of not less than 1,000 penalty units and not more than 2,000 penalty units, or to a term of imprisonment of not less than 2 years and not more than 5 years, or to both. And I believe you are aware of the Section 293 of the Criminal Act, which provides that where a public officer is convicted of an offense and is sentenced to a term of imprisonment exceeding 3 years or more, you are dismissed. Yes, that is the law. Land fraud by persons has been on the ascendancy and has become anathema to development, and it needed to be uprooted. The Act has prescribed a deterrent sentence for those who engage in those activities. A person who alienates land, which that person has no title, you know that it is not yours, or purpose to grant land without authority, or makes conflicting grants in respect of the same land to 2 or more persons, commits an offense. The land is not for you, but you have alienated it, or you want to alienate it. And if you are convicted, to a fine of not less than 7,500 penalty units, that is 90,000, and not more than 15,000 penalty units, that is 180,000, or to a term of imprisonment of not less than 7 years and not more than 15 years, or to both. So now, if you are selling land and you know that it is not yours, the offense is very deterrent. There are other offenses created. So now, if you have already alienated land, it is no more for you. If you go ahead to alienate, you commit the same offense, because at the time of the alienation, you were not the owner of the land, and you commit an offense. There are other offenses created for persons who claim to have interest in land and fail to assist. That is, if they fail to assist a surveyor or an officer appointed under the Land Act to demarcate a land, or a person who failed to comply with an order contained in a notice issued under the Act, or a person who obstructs an authorized officer in the performance of that officer's function under the Act, you commit an offense. Section 277 of the Land Act. Now, implied covenant. This is another milestone. The position was that we have 2 types of covenants. We have implied covenants, we have express covenants. And the English Land Property Act 1925 had taken away the powers of the court to imply into an agreement where the persons did not. So where the implied covenants provided under the then Conveyancing Act is not part of it, all of them are supposed to be express. So if they were not express, irrespective of the injustice, the hardship they may occasion, the law was that the court could not imply any term into it, because that power of the court had been taken away. Quite often, if you look at some interesting cases, one of them, Mreku and Tete, deceased, Mreku and Ades versus Tete and Ades, which is reported in 2012 1 Supreme Court Ghana Law Report. 520. The person's uncle acquired the land. It was passed on to him in his will. He developed the land into a 3-story. Then, after 10 years, the lease expired. Then he approached the lessor to permit him to renew. Then he said, no, look at the agreement. There is no express covenant to that effect. And I have examined the implied covenants provided by law. It wasn't part of it. So he said, as for this one, I will not agree. He went to court. He lost the High Court judge was very sympathetic. He said, oh, you have built 3-story within 10 years, so please enter into an agreement with him. He came to the Court of Appeal. Then Court of Appeal said, let's go back to the 1925 Act, which formed part of our law. And as at now, it forms part of our law. 19 provisions. Then it went to the Supreme Court. The Supreme Court said that where it is not an implied covenant under the law, you should have included it that after its fruition, you should have been given the right to renew it. Once there was no right of renewal, you lose everything. So he lost the building and the land. You know, people read and they will say that the court is not fair. It is not the court. The court follows the law. At times we apply equity, but where there is a statutory provision saying that you cannot. So the current position now, it has changed, and it has been made an implied covenant. The current position is that where a lease is made in respect of a bare land for residential, farming, or perennial crops, or a commercial or industrial property, and the lease and the lessee is an indigent, where the lessee is an indigent, there shall be automatic renewal of the lease after its fruition for the same duration. So if it were 90 years, if it were 50 years, and you were an indigent, automatic renewal, but with different terms. Where the lessee is not an indigent of the area where the land is situated, and there is no express provision to the contrary, there shall be an implied term for the lease. That is, it shall be renewal. It is subject to renewal, but not for the same terms and conditions. Then there shall be an automatic renewal for public lands granted by the Republic on terms agreed upon by the parties, unless the lease is in respect of commercial property or where the lease is required for redevelopment. So where the state requires it for commercial property or for redevelopment, that is where there is no automatic renewal. Now, the lands officers too. What is the definition of commercial property? Definition of redevelopment. The position for a lease granted by a Ghanaian to non-Ghanaian is that where there is no renewal clause in the express covenant, there shall be no automatic renewal. So if the lessee is not a citizen of Ghana, and there is no express provision that after its fruition he will be given the opportunity to renew, upon its expiration he loses everything, unless the person is very sympathetic and enters into another agreement with such a person. Another implied covenant under the Act is the authority given to an allodial owner to take over land in the possession of an usufructuary title holder upon payment of prompt, fair, and adequate compensation of not less than 40% of its value, or where possible, provide an alternative land where the land is required for expansion of a town or settlement, or will serve the communal interest of the beneficiaries of the allodial interest holder. That is section 5012, implied covenants for transferor. Then, restrictions on transfer of land by spouse. The Constitution required Parliament to enact a law as soon as possible on the coming into force of the Constitution to regulate property rights of spouses. Article 22 of the Constitution. The Land Act is the first act which seeks to address an aspect of the constitutional requirement. You know, the act was over-ambitious. The Constitution itself had stated that property jointly acquired during marriage, but the bill did not include jointly acquired during marriage. So Parliament has brought back the word jointly to change the meaning. So now it goes back to what is in the Constitution. The present position under the Land Act is that where a property is jointly acquired, so here there is a presumption now, where there is a couple, a property is acquired during marriage, we presume that it is jointly acquired. But where there is an evidence to provide that it is not a joint acquired property, then it is a different thing. So the presumption is that once you acquire the property during marriage, then it is deemed to be a joint property, apart from some few exceptions. And where variable consideration was paid, the spouses shall be deemed to be parties, irrespective of the person in whose name the property was acquired, unless a contrary intention is expressed in the conveyance. A spouse shall not deal with a property jointly acquired during marriage. Please, the word here is jointly, and not ordinarily acquired. Jointly acquired during marriage for variable consideration without the written consent of the other spouse, but such consent shall not be unreasonably withheld. If you are my spouse, the property is in my name, and you know that I'm entering into unproductive venture, and I want to use that property to secure a loan, you should not give consent. Because if you allow consent to be given, and at the end of the day he fails to pay, the property may be sold to satisfy the debt. So the drafters did very well, except that at the end of the day, the word jointly was taken away. Then decision of a court and a judge's certificate. The minister this morning told us that you may acquire land, you may have, the court may give decisions in respect of one land, about 2 or 3 decisions, conferring title in different persons. It is true. That's why nobody can dispute it. It is true. But if you go to Land Commission and you ask them, who owns this land? They may tell you. If you go to the land may be somewhere. And the land, which is the subject matter, may be somewhere. And the lease before the court may be lying somewhere. So there is no correspondence between what is on paper and on the ground. That is why I believe it took them 34 years for the introduction of the land title. How far have you gone to? Only Accra, Kumasi Township only, and Winneba. That is all. Why? Because of the antique equipment that were used to register under the title deeds. So let's look at conflicting judgments. Conflicting judgments of the courts contribute significantly to indiscipline in land administration and management in the country. A parcel of land could be a subject matter of 2 or more judgments, and each judgment may declare title in a different person. Therefore, each of the 3 different judgments on the same land subject matter may declare ownership in 3 different persons, and the courts do not have the means to cross-check as to whether there has been a previous judgment on the matter or not. In most cases, judgment in land matters and judges' certificates are not supported by side plans, and therefore capable of breeding several actions and decisions on the same subject matter. Some people have made it their stock in trade to perpetrate fraud in land matters. When they know that there is a judgment between A and B, they will go and initiate against C without the notice of B and A and B. Then they go and get judgment. Then another person would also go and get judgment in respect of the same land. And the courts do not have any means to cross-check. 10 minutes. I'll finish. To abate land frauds through decisions from the courts, the Act has made it mandatory for any judgment on land to be accompanied with a side plan delineating the boundaries. To ensure that authentic side plans are used, the Act provides that the attached side plans shall be approved and signed by the Director of Survey and Mapping Division of the Lands Commission, or a representative of the director, and further signed and thumb-printed at the back of the side plan by the parties and duly authenticated by the judge, magistrate, or registrar of the court. So now it has been addressed. Declaratory judgments. The court, you could bring an action in court, declaration. We just declare title. But the position has changed. The law now is that if you bring an action to the court for declaration. The court should not grant declaration. You must tell us the type of declaration, the interest that you are seeking. Is it allodia? Is it common law freehold? Is it customary law freehold? Is it usufructuary? Is it a lease, a sublease, before the court could grant you declaration of title? So that is the position now. Now let's look at the transitional provisions. Applicants who have pending application before the Lands Commission under any of the repealed enactments with the exception of the State Lands Act shall be processed by the Lands Commission under the Land Act, apart from the State Lands Act, the compulsory acquisition. All pending applications shall be registered under the Land Act. The interesting thing that we need to avert, there are a few interesting things that we need to avert our minds to. If you look at the law talks about repeals and revocations. Repeals and revocations. That is section 2A2. The following enactments are repealed. Then it talks about all the 13. Then the 2. Despite the repeal of the enactments in subsection 1, regulations, bylaws, notices. So here it has saved bylaws, notices, orders, directions. But it failed to save Public Lands Protection Act 1974, NRCD 240, which is a criminal enactment. Criminal enactment, the law is settled that every criminal enactment, if it is repealed, it must have a saving clause. If there is no saving clause, to the effect that all those who are being investigated, who are being prosecuted under this one, despite the repeal, they shall continue to be prosecuted. So now, all those who have acquired interest in public lands and they are occupying it, those who have acquired whatever form of interest in public lands and were either being prosecuted, investigated, or yet to be prosecuted, they cannot be prosecuted anymore because it was repealed by Parliament without saving it. And it is in complete violation of Article 1911 of the Constitution, which a decision has been rendered on it. British Airways versus Attorney General. So the way forward, let me sum up. I know that my good friend Samson. So we must comment it is a good law, very good law. But we must know that a bad law, which is well implemented, is better than a good law, which is poorly implemented. That is the first one. Then the LIs to be made, we must make sure that we make them as soon as possible. Then customary land secretariat, it must be set up as soon as possible, and the law says we need an LI. We may need an LI to support it. Then the police must collaborate with the Lands Commission. We must have the police, make them understand, do proper investigation, so that they can prosecute, else the penal sections of the law will become quite elephant. Then the court must change their attitudes towards sentencing and ensure that convicts under the Act are given deterrent and preventive sentences. Then, Order 11, Rule 7 of the High Court rules, which is to the effect that you cannot attach anything, that one should be amended to take care. Because if you issue a writ, and on the face of it, there is a side plan, it will address most of the problem and will not go a long way. Then another important achievement is the use of ADR, the alternative dispute resolution, to resolve disputes under the Act. In conclusion, all decks must be on deck to sanitize land administration and management, which has become a heaven for fraudsters. Thank you all for your attention. May the good Lord bless Ghana and make her great and strong.
Was that all you could do? I have sat in the land law class for a year, and then my teachers and my TAs, some of whom are here, have also assisted me. And right here, in 1 hour, the land law you have just learnt, you are going to take away my job as a lawyer. And this is all you could do. Please, a round of applause again. Because we are live on GTV and we are being followed on social media as well, it is not only those of you in this auditorium that are receiving this empowerment, but many more who are potential clients of us. We are losing our job. That's why I stopped him. All right. So we are going to keep to the time. By the time is 2:15 or less, we'll be leaving here. The lunch is nicely packaged and very sumptuous. Yes. We will do the second presentation, and then please note all your questions. Note all your questions. I've been so further empowered, I don't have any question for Justice Dennis Agyapong, but put your questions down. Let's now welcome Dr. Eric Yeboah from the Built Environment to talk to us about the role of professionals in the implementation of the law. A round of applause for him.
Good day, everyone, and permit me to stand on established existing protocols and acknowledge you all and say thank you for the interest you've demonstrated by your presence to indeed help, first of all, to delve into what the law provides for, but more importantly, be agents of it in putting the law into work in our respective place of work. Indeed, my task was to look at what the roles are for the built environment professional in the operationalization of this law. And in my preparation, I decided to take a step back and look at what are the key policy propositions, what are the key policy areas which have been given life by the Land Act as it stands. And then within the policy arenas as defined by the law, we could then tease out what is expected of the land professional as a role, so that cumulatively we could achieve the very spirit and expectation of the Act. And for reflections, and let me admit that I'm going to be the last speaker after 4 or so very powerful speeches on the same subject. So some repetitions and some cross-references to some earlier comments should be expected. But I guess repetition is for emphasis. And so for those areas where repetitions would be observed, it presupposes that these are pretty thorny issues within our land administration sphere, and for that matter requires careful attention as land and built environment professionals. So the Act, as we know, is a fusion of innovations and consolidating and harmonization of what existed, but more importantly, also codification of certain practices which existed, but didn't have a very clear legal basis to their practices. And so what the law has done is to bring these three dimensions into it, codify what existed but without clear statutory basis, but also harmonize and streamline the very many provisions at times which resulted in confusion for practitioners in this space. Now, we are the built environment professionals and the very primary user of this important piece of legislation. So in preparing for this and looking at who the built environment professional is in the context of the Act, we're looking at what would be the traditional conception of a built environment professional. And I saw this little picture there. I don't know how clear it is from there. This picture was taken, and it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry Act was passed. And it was a news report when, in 1997, the Land Registry A the Ghana Infectious Disease Center was being developed by the built environment professionals. And guess what names or what professional categories were listed? Engineers, architects, planners, surveyors. So traditionally, these are likely to come out as your immediate idea about who a built environment professional is. But in the context of the Act, we need to look at the built environment professional as a much more expansive field of practice. So there are different people operating at different levels in different spheres who are either directly or indirectly piecing together to create the built environment. So you have the primary ones, your land surveyors, your valuers, your lawyers, engineers, but you could also have the next layer of people you ordinarily not associate built environment with, your sociologists and the rest, who are indeed examining land relations from different perspectives, gender land rights, youth rights, and all those bits. So the land professional or the built environment profession then becomes a bit more broad from what should be the ordinary definition and conception of this field of practice. But also, another category, you may choose to call them the derived one. So if an IT personnel develops an app which is supposed to help in mapping or in your land transaction or anything, that person is not your typical built environment profession, but his role is feeding the person into that space. And it's important that we frame our idea about the built environment profession along this line so that the many provisions of the Act could be looked at from a much expansive perspective as opposed to what should be a narrower conception. Because all these people, as we go along, we see that everybody, either primary, secondary, or derived, would have a way or a role to play towards achieving the object of the law at one point or the other. So I mentioned earlier on that the approach to this presentation is to really look at what the policy propositions or what policies are being affirmed by the law, and then look at how the built environment professional is expected to play his or her role towards the realization of that. So the first policy proposition I want to highlight is the fact that the law, and a number of these issues have been touched on, but the law has enhanced recognition and strengthening of customary land administration. And for these ones which have been touched on earlier, I would be quick in going through just to save more time. But one clear thing is, of course, all the various shades of rights and interests, including customary tenancies, have been strengthened, been well recognized in law, treated as registrable. And so for vulnerabilities that existed to landowners and land users because of unclear definition of rights, this has been cured by the passage of the Land Act. Another thing that has been resolved is the fact that family lands and clan lands are hitherto were not really brought under the mandate of the Office of the Administrator of Stool Lands in their work, because they did not fall in the straight definition of the Constitution as has been already touched on. Again, the issue of greater accountability has been enshrined in this law, and there are a number of cases where customary landholders as fiduciaries deemed to have breached the terms of trust relations without anybody to look, without any call to demand accountability, and there is a provision for this, and it's important that as land professionals and built environment professionals, we take notice of these advances introduced by the law. Next, please. We've talked about the institutionalization of the customary land secretariat. Of course, these have been in existence, about 90 of them established during the various phases of the land administration project with varying level of success. But we have this firmly rooted in law now. And so landholding groups are required to establish this and ensure that they are adequately resourced in order to deliver the stated responsibilities, which should complement or which should indeed be the foundation space. If the land secretaries are working and working very well, which they should, land transactions and land records should be emanating from these entities and then could evolve into the Mainstream Lands Commission and the Land Registry. And so this represents an important piece of progress as we attempt to improve and enhance how land is administered in the country. And importantly, we have clear sources of financing for the activities of the CLS, which include portions of compensation paid to the landholding group in case there is compulsory acquisition, and also Office of the Administrator of Stool Land Revenue and related matters. And so this is an important piece in the entire jigsaw to really set the foundation of land administration in terms of land transactions, get the data from the primary sources, and then these could be scaled up and transmitted onto other relevant agencies involved in land administration in the country. Next, please. Now, if you combine all these introductions by the Land Act, either it's being codified or it's being an innovation and all, if you put all the introductions by the Land Act, either it's being codified or it's being an innovation and all, if you put all of these together, now there's a clear opportunity for the built environment professional to really shepherd a process which would help an evolution of rights towards greater formalization of customary land rights in the country. There is a continuum of land rights which explains that as land evolves or as pressures on land increases, there is the need for greater formality of land rights to strengthen the interests and rights of other people. And the provisions by the law and the responsibilities expected from valuers, expected from planners, expected from surveyors to work with, but also the private sector, to work with these customary land sector agencies, customary land secretariats, should help in the process of migrating customary land rights along the continuum of the rights in response to increasing pressures on land coming from population growth and all the many drivers of land pressures that you know. So here, as built environment professionals, there is the need to support the CLS to be efficient, to be sustainable, drawing from lessons from the earlier stages where of course, many did well, survived, did well, but a number of them could also not survive, could not become sustainable. The key question is, as built environment professionals, at the Lands Commission, as Stool Lands, as planners, how do we really team up to support the CLS, considering the fact that it is the first point of call in land transactions and by extension land administration in the country? So it's an important place for us as built environment to look at. I will skip this because it's been tied on. The next policy item I want to talk about is the architecture the law has put in place to indeed help in creating a transparent and a functional land market system where people have confidence in the land administration system in the country. Because we know that, indeed, what triggered the development of the national land policy and all was the huge indiscipline in the land market, characterized by multiple sales, lack of tenure security, and all that. And we know that land guards have been proscribed. A lot has been said about that. I won't repeat that. So that is an important demon and principality, if I'm to quote the vice president. So we have a clear strategy to really change this principality by prescribing this practice and not just making it, the responsibility of the guards themselves, but anybody procuring the services of these miscreants to wreak havoc in the land space. Another key provision of the law in Section 102D is the power granted to the Lands Commission to refuse registration if there is reasonable grounds to believe that the land the land being registered has features of fraud or any basis which is not permissible. So the Lands Commission is not, by the law, it's not only a passive administrator to document, but a responsibility has been imposed on the Lands Commission to be more diligent in their work of registration, because there is the power under the law to say that, hang on, this transaction cannot be registered, because it is the inability of the Lands Commission to, at times, decline some of these things, where, especially in the area of deed registration, anything brought to you, the instrument might be registered and all. And so that creates that situation where everything before you is registered, and we end up with 17 deed or title certificates with respect to a single parcel of land. Now, the law has provided a cure to that. The Lands Commission has been further empowered to decline invitation to register documents where there is enough basis to believe that something is not right. Another provision in the law to help in sanitizing the land administration space, next slide please, is criminalization of people who transfer without capacity, and this has been talked on again. Now, one exciting thing I found in the law is how detailed the drafters even went, to the extent that even the choice of words in drafting conveyancing has been touched on. So the more archaic, old school, difficult to appreciate expressions like, demise, situated line, and being at, and those complex, winding diction in drafting, which at times in itself become a source of difficulty, have been addressed. And it's straightforward. If it's a lease, it's a lease. If it's interest, it's interest. So all these, even the diction of how conveyancing should be structured, have been well catered for and provided for by the law. And as land professionals in this space, providing various advices, either in the capacities as brokers, estate agents, or lawyers, whatever role we are playing in facilitating conveyancing and land right documentation, we must be alive to some of these provisions in the law. And ultimately, it's to really make the system clearer and help improve the clarity and sanity in the land administration space, something that we all aspire for. Next slide, please. Now, it's a common feature for anybody holding land to be invited, especially when a new chief assumes office. We all have to go and greet the new man in the seat, and we know that it is not a mere case of greeting. At times, it's almost a call to renegotiate whatever consideration you might have paid earlier for accessing the land. But the land law, the Act is very clear. If anybody with a capacity to effect a grant is doing so because the person is deemed to have, or the authority to grant, is almost perpetual in succession, and it goes beyond the individual grantee. And so when there is a change in the person who effected the grant, it does not necessarily invalidate the grant in any way. And so grantors or their successors or whoever is taking the have thus been prevented from this usual practice of inviting people and almost asking them to pay for the same thing twice. And I think this is an important development in the built environment space. It's something that is going to bring a lot of peace and relief to many people who are often victims of this practice. The law has also made provision on issues on re-entry and repossession of granted lands. There is almost this provision of you're supposed to commence development within 6 months and complete development within 2 years. Failure to do that, the grantor is empowered to re-enter and all those things. And yes, we may appreciate the import, of some of these things, to prevent people from speculating, so that once you don't hold land which should be productive, you don't hold it and just speculate, so that when there is a spike in land values, you just sell to criminal. But the intention may be well, but in practice, these provisions have been many sources of confusion and contestations in the land administration space, and contributes to the many instances of indiscipline. And so the Act has provided a cure to that. So there is a well-defined process which should be followed if there is the need to do that. And so as built environment professionals, we need to take notice of this provision which guides the ability of grantors or lessors to re-enter and repossess lands if there is any breach. Of course, you can only do so if you've provided opportunity to the lessee or the grantee to amend or correct whatever the defects based on which you are going to mount your grounds for re-entry. Next slide, please. One of the sources of indiscipline in the land market has always been delay. The provision, but the law has made a very emphatic direction, and I see this. I'm excited about this provision, not because of this provision in itself, but the signal the law sends out to operators within the built environment space, particularly those at Lands Commission. So the law is now saying that search reports must be done within 2 weeks, within 14 days. The search report must be done. But my excitement is not just this. It gives indication that we should be aspiring towards providing workable timelines to all shades of land services which should be assessed at the Lands Commission. And so we've been talking about, and the Minister made reference to it this morning, a 30-day turnaround for land title registration, and all those categories of services we provide at the Lands Commission. We need to have timelines, and these are not timelines just to fulfill all righteousness. These are timelines which should be workable based on the internal systems and workflow practices within the Commission. This should be something that is practical, that is pragmatic, so that it can help infuse greater confidence in the space. So if we know that you can get, if you are applying for this service, it's supposed to take this length of time, and you are indeed doing that, that is a major source of confidence into the system. And ultimately, all these pieces come together to really sanitize the land administration space and infuses confidence into the system. Another point of interest is how the Act has tackled issues relating to large-scale acquisitions. Not long ago, this was something that almost threatened to take over the entire country, because you would wake up one morning and it was like one company from nowhere has acquired 100,000 acres of land for Jatropha, for this, for that, and it was almost happening on a daily basis, 50,000 hectares, and it was scary, and so there was the need to stem that tide that was really happening. Of course, Lands Commission rose to the occasion, mobilized, and there was a large-scale land acquisition guidelines, which I'm sure a copy is in all the packs which have been distributed. Now, the Act has gone a step further to, first of all, define what is large in the context of large-scale land acquisition. And the definition is that for urban or lands for residential, anything in excess of anything 4 acres or excess is deemed as large. And if it's for agriculture or other purposes, 20 hectares is large. And therefore, when you cross this threshold, the relevant guidelines should kick in. The Regional Lands Commission have been given the power to request other documents from anybody acquiring large land under the Act. And although the Act is silent on what other documents the person seeking to acquire should bring, if you look at the spirit and all the discussions behind, I'm tempted to believe that drafters had in mind the guidelines as has been developed by the Lands Commission and any other similar documentations which have been developed on this thematic area. And so the guidelines by the Lands Commission, provided opportunity for greater transparency and also offered safeguards to gender and people on gender matters. And more importantly, the Act, Section 44, one thing that made the incidence of large-scale acquisitions of concern was that it was almost colonization being revisited on us. 100,000 acres of land taken for 50 years, and the valuable consideration paid is a rickety Toyota Corolla or something. It was, at times, it almost felt like insults, So the Act has strengthened this position. Now, any acquisition based on such unfair terms can be set aside on the grounds that the contract was unconscionable. And the basis of determining conscionability have been also well outlined in Section 44 of the Act. So if you look at all this together, you could say that the Act has further strengthened the position of built environment, working together with Lands Commission and all stakeholders to really sanitize and improve how land acquisitions, large-scale land acquisitions, should go ahead. I've been prompted. I have quite some limited time, so we'll see how fast we could run. We'll talk about the alternative dispute resolution. We know that our courts have forever been very congested with land cases. Different estimates will give different figures. At times, it's been stated that about 40% of all cases are land or land-related. And so what the Act has done is to indeed resort to alternative dispute resolution as a first call if there is any contestation. And I did a count. I counted 22 instances where any land-related conflict should first be tackled through ADR. Perhaps there could be more. I counted 22. And Section 91(4) was very telling that a court shall not entertain an action concerning dispute as to the boundaries of a parcel within a registration district unless the process of settlement based on ADR. So you cannot even go to the court under such a condition unless you've next slide, please. Unless you've attempted to settle through ADR. And what this tells me is that there is huge opportunity for the built environment professional to really build capacity in the area of ADR. Perhaps the Lands Commission may need to consider looking at the responsibility the Act imposes on it and also the push towards ADR. Perhaps it may be worth having your own internal directorate of ADR so that you could work with other colleagues in the built environment professional to indeed make bring life into these many provisions which the Act has made regarding an alternative means of resolving land-related dispute. Of course, this should help to decongest the court and minimize the incidence of the many, many years where cases have to drag on and on at the court. Next, please. We've talked about the digitization, something that is very exciting. The point I want to add to that, we've gone through, there's no need to belabor the point, but the digitization or the e-conveyancing as provided by the law, again, in my reading, is only indicative, and it gives signal to the Lands Commission in terms of what it should do. It's not solely limited to the e-conveyancing. There are many, many areas the electronic land administration system should help. For example, there is the need to embark on massive decentralization in the delivery of land services, so that this over-concentration of demand at the regional land commissions and the very few district outlets would be a thing of the past. Now, to make this possible, you need to leverage technology so that with your digitized land registry and leveraging technology, you could indeed decentralize land administration and make it workable to people, take pressures of the center, and then ensure that there is speed. So the e-conveyancing goes beyond just the conveyancing, in my mind. It involves building a whole enterprise of land administration solutions, which could help in speedy delivery of land services. And if we build this, the incidents that Ajay described, where because courts do not have access to the maps or the site plans accompanying cases are not reliable, will be a thing of the past, because there will be interoperability between the Lands Commission records and the judicial records, and the judge or the person overseeing the case could, because of the electronic workflow processes, could indeed have the opportunity to confirm some of these site plans and all before decisions are even taken. And the interoperability is not necessarily going to be limited to the judiciary. Many other state agencies, National Identification Authority, GRA, Senate, and the rest, all in one way or the other have interest in land. Financial institutions, banks, and all. They could be speaking to the records of the Lands Commission through the electronic administration of land records. And so this is an important thing, and we must look at it broadly as land administration professionals. Yeah. Next, please. There is also the issue of mortgages, and it's been touched on. Lands commissions have been put at the center of making the mortgage market work, because for any mortgage to be effective, it must be registered by the Lands Commission. And so any delays, any inefficiencies on the part of the Lands Commission is going to threaten the entire mortgage market. And as the Vice President alluded to, it's at the heart of economic development, really. And so there is a lot of responsibility on the Lands Commission in this regard. But it's not just for the Lands Commission. We know that structuring mortgage transactions is a complex thing involving many of us, valuers, lawyers, and all. And so this is something the law is providing direction to really amplify in our work as built environment professionals. And so we need to sharpen our skills in order to make this work. One thing I also noted, which is another exciting point of the law, is that the law has acknowledged that property development at times includes multiple flats and condominiums. And to date, so you could have one structure, the land in the name of one person, but 10 floor with 2 flats on each floor, 20 flats sitting on one land. Each flat could be acquired as an independent, separate entity. How do we really document the rights of these 20 people, 20 separate people sitting on the land that belongs to somebody else? So our inability to really crack this has been a major factor undermine the mortgage market. And here, the Lands Commission has been tasked to provide regulations to make it work. And again, it is not a call or a mandate on the Lands Commission alone. We will have a role to play as the built environment professional. Next, please. Yes, and then issue on systematic registration. I'll be fast. I understand I have just about 5 more minutes left. So our approach to titling has been sporadic. So you get up, you feel like registering, and you go and register. But that has created a problem at the Land Registry. We don't really have a comprehensive records to really tell us that if you go to the field, this is how it is. To cure this, the law has mandated the Lands Commission to have the power to compel, if an area is declared title area, and we have to really do land titling in this place, you don't have the option to opt out. You are mandated to register. And if you fail to do that, the Lands Commission would write to you, notify you, and failure to do that, you'll be compelled, because an action can be instituted against you for not registering your land. I think this is a great piece of innovation. Again, it's a call on us as built environment professionals, especially our friends in land surveying practice. It is a call to help because we need that competence, we need that skill to indeed make this provision of the law to ensure that there is systematic registration work. We have the power to make it work, and as land practitioners, we have to support the Lands Commission, indeed ensuring that when an area is declared as title registration district, everybody's land is registered. The Lands Commission will not have internal capacity to cope with the volumes. And so there is an opportunity for the private practitioners to play a role in here. Next, please. Another important piece of work done by the Act is how there has been an interfacing between land administration by the Lands Commission and the land use planning. So now land administration has a strong relationship with planning, and the Lands Commission is expected to have maps of all the local areas. And the important thing here is that if there is an approved plan for any local area, any allocation made that is not consistent to the provision of the local plan is void, ab initio. So this instance of a place being zoned as, reserve or park, and then the following day people are springing multi-million mansions there, should not happen. And indeed, we should not allow it to happen, because we have the power as built environment professionals under this law to declare any purported alienation of land for uses inconsistent with what the plan provides as null and void. And it's something that we need to take note as built environment people. Next, please. There is the spousal rights, something that always generates excitement and controversy. But of course, yes, it's been talked about differently. I will skip that in the interest of time. Next, please. Next. The issue of compulsory acquisition. Now, the Constitution provides for fair, adequate, prompt, whatever. But in practice, this has never worked. There are some 50-year outstanding compensations, and it keeps on and on and on. But next, please. The spirit of this law, what the law has provided to cure, is that, next, please, that now you cannot acquire if you don't have funds to pay for compensation. Essentially, that is what the law is telling us. And so, if a state entity has to acquire land, Cabinet must be in the know, and the Ministry of Finance must commit to putting it in their budget, so that as we are passing the executive instrument to acquire the land, the money is ready for for payment of those whose rights would have been extinguished by the acquisition. And if there are other bodies other than the ministries, departments, and agencies, you are not only expected to prove that you have the money to pay, you are indeed expected to lodge that amount in an escrow account, which will be managed by the Lands Commission. So this is an important step to indeed operationalize the constitutional expectation of fair, adequate, prompt. So if we kick this provision into action, then certainly that would be achieved. There are other exciting provisions under the compulsory acquisition, especially when it comes to distribution of compensation. Hitherto, crops and improvements will be paid to the individual people, but the value of the land per se, in practice, was likely to be given to the allodial title holder with the lame expectation that this person would use it in a way that would benefit everybody. But in practice, hardly ever did that happen. The Act has moved a step further to say that, okay, for these are recognizable interests on your land. And so in terms of compensation, and we know as valuers that every interest or right in land can be valued. You can determine the financial worth of these registrable or recognizable rights. So this provides a new twist to the work of valuers working on compensation issues. Now we're going to have to earn your dollar by really disaggregating these interests and determining their financial worth so that there is equity, there is fairness in the administration of compensations from compulsory acquisitions. Next, please. Next. You are holding me up. I'm under pressure to finish. Go. It's okay. Next one, please. Again, next. Okay, so this is an important provision. The Lands Commission has been mandated to continuously train its staff under 74(2). But the next point, next slide please, is very telling. There is an indemnity provision in the law, and I'm glad my law justices are here to further shed more light. So if somebody suffers losses or is unable to register or incurs any loss based on working within the Lands Commission, such as ratification of a register or a mistake or omission, or if in your work at the Lands Commission you cause somebody a loss, the person could potentially bring an action against the state for indemnity based on what is at the 196. And I'm sure we're going to receive more legal education on this. But if this is the case, then there is a lot of responsibility on the Lands Commission, because the state is required to indemnify people suffering losses based on the work or activities of the Lands Commission. And this is an important thing for us to note as built environment professionals. Next. Another point which has also been talked about is that there is a clear sanctioning regime under the Act. So a public officer certainly would have to face outcomes of their unprofessional practices. Next, a professional is equally liable for all sort of actions if they are found to be unprofessional and their actions result in any loss to any individual. So again, there is that kind of clear sanction in terms of what to be done if something goes wrong. Part of this is also has to do with the registration in terms of the sanctioning regime. So if a land is registered, we talked about the fact that land use planning and land administration there's greater interfacing through the Act. But if a plan is in existence and you register land that is not consistent with the plan, it's also a ground for sanctioning by under the law. So it's not just the person altering land records and all that. It's everything. Next, please. I'm a teacher. Next. I guess I spent like 3 minutes just prompting him to go to the next slide. So we're saying that in terms of reflection and conclusion, we're saying that it's a great piece of law, and we all have a responsibility to transition this law into practice. But let our optimism be guided by some level of caution. Because I was surprised when I was plowing through the land administration literature, and I came across the fact that in 1876, we actually enacted a land act. Way back in the colonial era, there was a land act. And centuries down the line, we're still having this conversation. What it tells us is that a good law is great, but it takes action. It takes implementation. It takes conscious effort to really make it live and achieve whatever the intended purposes are. And it is against this background that I call on colleague built environment professionals to embrace the challenge, face it with new mindset, guided by hard work and ethics, so that the many, many exciting provisions of the Land Act would not only be good for the test of it, but it can inform and shape our practice. I want to thank you for your audience. Thank you very much.
Thank you very much, Dr. Eric Yeboah. Please give it up to him again. So, I know you're tired sitting, and as I promised, we may do under the time that we had apportioned to ourselves. So we are all doing very well. We are now getting to question and comment time. If you have a question, you do it very brief, under 30 seconds. If you have a comment, you do it very brief, in 1 minute. So in a minute, you can make a commentary. In 30 seconds, you ask a question. So if I were you, I'll start writing my question so I can ask it direct. Our guests will remain on their seats. They have microphones by them. I'll plead with you to kindly adjust the microphones to yourselves so that when the questions come, we can take them. Now, for the sake of the television cameras and not to disturb their coverage, I would plead with you that you come in this aisle if you have a question, and if you are on the other side, you can be in the aisle where you have the camera. So we'll use this aisle and this one, and I'll hand the microphone to you to ask your question. Right, so there's actually a microphone here and a microphone there, correct? There's one here. So if you have a question, please stand and approach the microphone. But before that, let's have my Lord make a comment, or if it's a question.
To Dr. Yeboah for his brilliant presentation. But he seeks to limit the content by built environment. I don't know why he's trying to do that. That's not what is in the program. And the content is excellent, and it's just the environment, because the Act doesn't relate only to the built environment. It affects agriculture and everything. And I'll suggest that you take out built environment and just leave professional and brilliant presentation.
Thank you very much. Please, we have a microphone here, one there and another there. Please approach it. Introduce yourself briefly. If it's a comment, under 1 minute. If it's a question, under 30 seconds.
To tell our brother Justice Dennis, you know, he touched on some of these things, especially the NRCD 240, which cases are still pending in court, and there are lawyers everywhere were following it. If your lordship plus the other ones that you know that need to actually be adjusted, the law hasn't gone far yet. If you could make those suggestions, I mean what I won't say suggestions, because now it is a reality that these loopholes are there. If you could present that, and then the Parliament should look at it and do the necessary amendments now. I think that is my advice. Thank you.
Thank you very much. Yes, please introduce yourself. I suppose it's on. It may take a while to respond.
All right, I'm Lancelot. Okay, the question is, does this Land Act take into account or make a provision for limitation as to the size of land an individual or an entity, may acquire a land? I'm saying this based on the backdrop that we have, real estate developers or individuals who, by the virtue of the fact that they have the financial muscles, are able to acquire huge, plots of lands. We can make, case for, areas like Pram Pram, Dawenya, even Kaswa, and areas where these entities have acquired land, and they are intent selling the lands to the, the community. Mame Sewa is watching, or Semin Kekri, or so what asase, if you being chained. Na asase no toye no, or hineno, edin such as say. In Fiemi no, it do no ye bibia wo asase ne soa. Ombeba beja asase no, every nisem. Or say me bisa say emrano. Titu, adeben potimpa na eka. Thank you.
Thank you very much. I think that for the last question, as in the last and the first that he asked, we can have my Lord address that. Is there a limitation to the amount of land or size of land anybody can acquire? And you have addressed the issue, but you may have to explain that further to him.
Thank you. Thank you. Thank you. Section 22 deals with restrictions on land, that is for natural resources and farming rights. And this is not the first enactment that has introduced restrictions on lands that could be acquired for other purposes. But it is because of the consolidation. That is why it seems to be a novel provision. It is not a novel provision. If you read section 22, it says that despite the provision to the contrary in any other enactment, a grant for farming rights in a stool, crown, or family land shall not exceed. So where it is for poultry, 25 years. Then where it is for ranching or cultivation of tree crops, 50 years. Then you come to the 2. It talks about the sizes. A grant or aggregate of grants of stool, crown, or family land to any person shall not exceed, in respect of where it is mining rights, which is not material here, where it is timber rights, 103.40 square meters, then where it is for animal husbandry, then 2.59. So it has limitations. You cannot acquire every land. When you are acquiring, the limitations have been provided for.
Well, the second question is about it says Mamia, who has acquired land, and is being told that if she doesn't develop in 2 years, it will be taken back.
All right. That brings us back to re-entry. Re-entry, if you look at the original one made by the drafters and contained in the bill, it was well crafted. It was very well crafted. That one, it provided that you can re-enter or forfeit. Then it used a legalese that where there is a legal, but Parliament, unfortunately, at the end of the day, deleted some of the words. So the original draft was very perfect, but some words have been deleted. But all the same, it doesn't change the meaning. Now, the position is that if you acquire land and a time frame is given and you fail to develop it, they will re-enter. And when they are going to re-enter, they will comply with Section 57 of the law. First and foremost, there must be a notice to that effect. Then it must specify the breach. Then if it is remediable, you should be given the opportunity. So where you have been given the opportunity, that is build within 6 months, complete within 2 years. And there are several judicial decisions. You may not get all of them from this one. There are several judicial decisions to the effect that where you give somebody a year to build and complete within 2 years, but the land has not been approved, time will not run against the person. So it is case-by-case basis. But on the whole, if there is an agreement and there is a violation, then they can exercise the right of re-entry, and it always goes with notice for you to first and foremost remedy the breach.
Thank you very much. Yes, please introduce yourself and your question.
Thank you.
The person next to you, do you also have a question or a comment? Okay, so you ask right after.
Mr. Laddie, perhaps, hello? No, I'm here. Mr. Sampson, I want to add something brief to what my Lord Justice just said. So the person who asked the question wanted to find out if there are any statutory limitation in terms of the size you can acquire, and my Lord Justice has taken us through. But the key thing you have to remember here is that if it's an acquisition for mining and other related purposes, they are guided by the Minerals Commission and other relevant legislations. And you cited real estate development in the Kaswa area. And I mentioned that if it's beyond 4 hectares, it is defined as large-scale acquisitions, and the relevant provisions set out in the law must be complied with. So, of course, you can acquire large-scale land for development, but the process of the acquisition would be different from somebody acquiring 100 by 70 land for development. So that is the addition I wanted to add to that.
Thank you so very much. Yes, please.
Thank you. My name is Dixon Akogan. Section 281, the interpretation section, defines two land, and they took away the captain of a company. But when you go to Article 295, two land includes the interest of a captain of a company. I'm interested in knowing why captain of a company is taken out of the Land Act, and what even the captain of the company meant in the first place. And secondly, the drink money that is collected by the traditional authorities. Now that they are fiduciaries from both the stool to the family to the clans, are they also accountable for the drink money, which we know that sometimes equates to the economic value of the land? Thank you.
Thank you. Next, please.
My name is Boati. Yeah. Is it possible somebody have a land title and someone that don't have a name, nothing on lands commission, his name is not there, to put injunction on someone who have a land title, and they put injunction on the one who have a land title, but the one who even asked for the injunction don't have a name, nothing in what you call lands commission. He said his uncle sold the land to the person. Is it possible like that?
I don't understand.
Thank you. Thank you for your question. Yes. Please, we take the person just by him, then we come to you. Yes, please go on.
I am Ernest Kuban. On the issue of the company ownership, if the shareholders are indigenous, at the point they have all the rights, but what happens when there is a change in the shareholding from an indigent to a foreigner? And also, with
please, can you repeat that question?
On the issue of companies owning land, right now, if the if the shareholders are Ghanaians, they have rights of the 99 and even renewable and all that. Now, after the acquisition, if there is a change in in the shareholding structure or like shareholders? What happens to the rights that the former shareholders acquired in the name of the company? And also, with the implied renewal for an individual, that if I buy land and in the indenture, it is not even stated that, oh, maybe at the end of the 99, I can renew. Now, we are saying that there is an implied renewal as long as I am a Ghanaian. What happens if after the acquisition, I change my nationality, or maybe my children come and they also go to other countries and do that? Thank you.
Yes, no, please wait. Yes.
Yeah, my name is J.C. Akwa from Ghana Institution of Surveyors. We thank God the land bill has now come to stay. But what is left is the implementation to make sure that it will work very well. We need surveyors to be regulated in this nation. Because of that, I want to say that the Survey Council bill should quickly come so that I'm praying that the Survey Council bill also come to be implemented so that the two can go together and have a successful implementation of this. My main question is that where land title is being is taking place is declared by law. Now, we know the whole of Greater Accra has been declared title zone, but a portion of Greater Accra is still being documents are still being prepared from other regions, like Eastern region. For example, what I know about is the boundary between Accra and Eastern region. I want to know when Lands Commission is going to inform the people in the Eastern region to stop registering lands over there.
Thank you very much. We will take answers to these questions before we take another batch of questions. The very last question should definitely go to the Lands Commission. So can we have anybody from the Lands Commission respond to the last question? The Lands Commission. Anybody ready? Yes, please.
The question of some of the regional boundaries is a subject of debate. These are administrative boundaries that have been established by law. But the implementation of the boundaries itself on the ground has not fully taken place. And I think that arrangements are being made to do that. It is particularly worrying for Accra, Greater Accra's Eastern region and Greater Accra Central region. But I think steps are being taken to make sure that these are delineated. What we also have to bear in mind is that sometimes the customary boundaries are not necessarily coterminous with administrative boundaries. So you may find a particular customary boundary which straddles between these two jurisdictions, and sometimes it creates these difficulties for us. But it is an issue that is being addressed. Thank you.
Thank you very much. So we have questions from Dixon, Boating, and Ekuban. Dixon has issues with the interpretation section. He wants to understand what captain of a company means and the implications that he asked about, and then whether because chiefs are fiduciaries, they are going to be accountable for the drink money that they take, sometimes which is a lot of money. And then Boating's question can someone who has no land title secure injunction against one who has land title? I think my Lord can address that.
When we look at the interpretation section of the Constitution, Article 2, that is Article 295 of the Constitution, it defines stool land to include any land in right over any land controlled by a stool skin, the head of a particular community, or the captain of a company. You know, the captain of a company, when you talk about captain of company, paragon, it is equated to stools and sub-stools. So if you look at the one in the Land Act, it says that includes land or interest in or right over land controlled by a stool, skin, or head of a particular community. So the head of particular community has the same meaning as a company. It hasn't changed the meaning, except that it did not use the same words that were used in the Constitution to redefine what we mean by stool land in the Land Act. The meaning does not change; it is the same. But it is about the choice of words. Then the other one, where you are a citizen of a company, then a company is a Ghanaian company, then they acquire other citizenship or the shareholding varies. The law in Ghana is that if you are not a citizen of Ghana, you cannot acquire interest in land exceeding freehold. So if now I am a citizen of Ghana, I have a leasehold interest of 99 or 90, and I change my citizenship, and tomorrow I am Togolese, I will lose my interest up to 40, not more than 50 years at any one time. So that one, it is automatic. So where you have a shareholding, and Ghanaians have 60%, and now Ghanaians have 40%, it has ceased to be a Ghanaian company, and should be regulated by the definition of who is not a citizen of Ghana. So automatically, it will change it. But it shall not render it void. It will change it. Unlike, because if you read the law itself, the Constitution itself, where you give a non-Ghanaian a freehold, that one is void. But if you give a non-Ghanaian an interest exceeding 50 years, it automatically it will be converted to 50 years. So we'll use the same interpretation to regulate it. Then the other one was
attached to that was the question
injunction.
Before the injunction, he was asking that if he acquired and later nationalized, for example, naturalized and became a Ghanaian, does the interest change?
At the time you acquired, what was your position? You were non-citizen. So if you want to change your position, you must reapply to acquire it. It is a different regime. But at the time that it was acquired, you were not a citizen of Ghana. So now you have become a citizen of Ghana. If you want to acquire a higher interest, you may reapply to your grantor.
My Lord, now to Mr. Boateng's question on injunction, whether one who has land title, one who has no land title can secure injunction against one who has land title.
Thank you. When we are in court and we are granting injunction, we take a lot of things into account. We take, number one, we take the rights of the parties. Do you have a right to the land? The person will say, yes, I have a land title. I also say that, no, he has, but it is fraudulent. I have been on the land for 40 years. In that sense, I have possessory right. So the court will look first and foremost at the rights that the parties have in the property. If they have rights in the property, then the next question is balance of hardship. Who will suffer if an injunction is not granted? Please, we must understand that where land title is fraudulently obtained or mistakenly issued, it can be cancelled. Even though we say it is indefeasible, there are grounds upon which it could be invalidated. So the fact that you have it does not mean that the court cannot grant an injunction against you. Where the court is satisfied that the person who has brought the application has a right, and the right is to be protected, the court will decree an injunction against you.
Thank you. So, yes, you can ask your question now.
Kobold, and the Ghana Institution of Surveyors.
Please, the name again.
Kofi Kobold, Surveyor Kofi Kobold, Ghana Institute of Surveyors. And I just want a little clarification. In the situation where a non-citizen has a freehold or a leasehold more than 50 years, automatically converts to 50 years. But the reference date is August 1969. And so as we speak now, it means that the person will not have any. So I don't know what in this act is trying to imply, because if the reference date is 1969, and it means we are already more than 50 years. And so what is that implication in this article? Thank you.
Thank you very much. My Lord, if you may answer him.
And it is published in the Gimpa Law Journal, 5th edition. The law was that the Constitution stated that you have 50 years lease, effective from the date, that is 22nd of August 1969. So when we are calculating dates, we deduct 1 day. So on 21st of August 2019, all of them lost their interest, but they were permitted by Lands Commission to apply for renewal. Most of them, they were given the opportunities to apply for renewal. So right. If you took advantage of that one, then you may be granted. But if you did not take advantage, it has lapsed. So now you are illegally in possession of that land.
Thank you. 2 questions. Yes, you ask first.
All right. Thank you very much.
It's on. Yes.
My question is on the renewal option that has been introduced.
Please introduce yourself. I seem to see you, but the mask doesn't help me.
All right. My name is Frank Jemfieboa.
Okay, Frank Jemfieboa.
Yeah, KNUST, Land Economy Department. The introduction of the renewal option is a good thing. One thing the Act, though, doesn't really address, it talks about the terms, and on new terms. And one of the key issues that will come up will be the cost of renewal. I've had a chance to write articles on that issue. I feel you may have a right, but if the cost imposed by the lessor is such that you cannot meet that obligation, that right effectively is, is not there, right? And so what would you recommend as a way of making this right exercisable by many people, and the cost not becoming an impediment in exercising that right?
Thank you.
Any of you can answer that. Thank you.
Thank you. My Lord, please, let's take the question before
the law
the
is
next
certain
one.
that the parties must agree on the terms and conditions upon renewal. So where upon renewal, the parties are not in agreement as to the amount to be paid, then it makes it mandatory for them to resort to ADR. That is section 50, subsection 15. Where the parties fail to agree on terms for renewal of the lease, the dispute may be resolved by the alternative dispute resolution. But if they fail, then they must settle the dispute in court. It is expressly stated. So use ADR. Upon failure, you go to court.
Right. Before that, my Lord, there was this question that had that was 2-pronged. The questioner reminds me that the portion about your education, that the chiefs are in a fiduciary position, what then happens to the drink money they take?
The drink monies, the Supreme Court has given a decision. I can't remember the case offhand, but the position is that it is not considered as part of income or royalties, because you have visited the chief. Then you tell the chief, oh, get this one to buy this, get this one to buy. So,
okay, so I can see a chief giving my Lord thumbs up. Please introduce yourself and ask the question.
I'm Prince DeGrant Brampton from Auction Export. I want to ask, what are the advantages of creating a land administration system? The advantages of creating a land administration system.
All right.
I do not
Thank
get
you
it.
very much.
Another question. I want to ask that what is meant by the direct principle of the
state policy.
Constitution.
Okay, thank you very much. Thank you. All right, so directive principles of state policy are clearly constitutional matters. That's not related to what we are discussing here this morning. But you want to know what is meant by...
Maybe because of Article 36(8),
right.
The fiduciaries.
Okay. All right, my Lord, if you may want to respond.
All right, when you talk about the Constitution has various chapters dealing with particular areas. And if you talk about Chapter 6, the Chapter 6 is on directive principles of state policy. And what it says is that we want to achieve a free and just state at the end of the day. So what are the objectives that will lead Ghana to achieve those objectives? And the objectives, we have political objectives, economic objectives, social objectives, educational objectives. But their legal position is where we're having some difficulties. If you pick that of Nigeria, it is stated that they are not justiciable. You cannot go to court in respect of them. But Ghana's one, there is no such position. So the first decision, that is the 31st December case, the Supreme Court held that everything in the Constitution is made to be justiciable because there is no exclusionary clause. But the second case, if you look at those in the those directive principles in Chapter 6, about 99.8% of them are found outside Chapter 6. So when they are found outside Chapter 6, then they are justiciable. By the current position of the law, that Ghana Lotto Operators Association, the law is that they are presumed to be justiciable, where the basic conditions are met. So the position now is that they are presumptively justiciable.
Thank you very much.
Justiciability means that you can go to court for a determination to be made.
Thank you.
Which is different from enforceability.
Right. So, Doc, can you take the question by Prince Buampong about the advantages of a land administration system? It may be broad, but can you help him out?
I'll try. I think if the technical people are there, you could beam the last but one slide, if you could do that quickly. So we are interested in this discussion of land, not because of the beauty of it, but because we know that no country in the world has ever developed without sorting that land administration system out. Land is the single most valuable asset of any nation. And there are a number of benefits the state, in fact, it's elsewhere been described as, by De Soto as the huge potential that needs to be unleashed for the debt capital that needs to be unleashed to drive development. We've talked about job creation. For example, we can start about a firm land administration system is important in improving access to housing, because access to land for housing development is a major constraint. It improves even revenue mobilization to the states in the era of COVID and austerity. What you need is domestic revenue mobilization, and land-based and property-based taxation are your go-to if you can really know what exists where. And you can only do that if you have sorted out your land administration system. We are looking at ease of doing business and access to credit from the banks. The Vice President mentioned that. Banks are either not prepared to lend to you because you don't have clarified way of securing the loan, or even if they are going to lend to you, it's at throat-cutting interest rate. And a number of them. We could always go on and on, but the essential thing is that no country can develop with a dysfunctional land administration system. And so the discussion we are having here has far-reaching implications for our collective development as a society.
Thank you very much. We take our very final batch of questions and contributions. If you have a question, please stand by the microphone right now. If you have a contribution, do so now. Afterwards, we will take no further questions or contributions. Right.
Just adding to the
Please
point.
introduce yourself.
My name is Joseph Kujo, MP for Efia Constituency and Minister for Public Enterprises. Just to add to the advantages of an effective land administration system. Certain at the Ministry of Energy, as a former Deputy Minister of Energy in charge of Finance and Infrastructure, we were relocating car power from Tema to Takrady, and the cost implication for the project made me realize that when it comes to land administration system, we should get it right by any means necessary. Because just imagine a time-driven project What? A gas pipeline and a transmission line and land issues delayed the project for more than 6 months. Short distance. And the same problems persist when you're doing transmission lines, when you're doing utility lines in this country, because you get to a point and because the landowner cannot even be identified, litigation issues arises and delay these infrastructure projects. So what we're doing is a very multifaceted solution we provided through the Land Act, as I see it.
Thank you very much. And that's such an important, intervention. Please, your name and your question or contribution.
Lands Commission. So when you look at the Transitional Provisions, Article 283, subsection 1 says, an application pending before the Lands Commission, before the coming into force of this Act, shall be processed by the Lands Commission in accordance with this Act. Then the next one says, despite the repeal of this Act, for a compulsory acquisition of land shall commence, which commence before the coming into force of this Act. So we are asking, when do you say an application has commenced, and when do you say an application is pending? We need clarification on that.
Which section is that again?
283.
Thank you, Mabel. Yes.
Thank you. My name is Nana Amayira. I'm the Executive Director for Colanden, an organization that works on land rights. So my question or comment, how we put it, is that it's a good thing to see that the new Land Act has provisions for the setting up of customary land secretariats. However, I have concerns that usually when we meet at this national level, where we discuss critical matters relating to land rights, land tenure security, or general issues that need attention in the land sector, we usually focus the conversations mainly on urban land rights or residential commercial. Yet, we know that as a country, our focus mainly is on agriculture, where we have a lot of the population engaged in agriculture, smallholder farmers who are acquiring or using smallholder pieces of land for farming. They have plenty issues, they have many challenges, and yet when we meet at this national platform, our conversations focus mainly on the urban center, commercial, residential property. So that is an observation. But in that relation, I am asking that what extent is the Lands Commission fashioning out an approach to work in a speedy manner to get the customary land secretariats functioning in all the traditional areas so that they can really help to address some of the critical issues for these populations that is usually untouched or unserved. Thank you.
Thank you, Nanama. Next. So, Lands Commission, you get ready. You have a question to address.
All right. My name is Jeffrey Tete, and I represent an organization called the Coalition of Land Associations. In the first place, I want to go to the tail end of Doc's presentation, where he said that government would have to actually compensate for omissions and commissions caused by officers at the Lands Commission. And I just want to find out, for clarity, why the taxpayers' money, my money, must be used to settle for someone's omission or commission at the Lands Commission. It doesn't sit well with me. And then I want some assurances from both the Lands Commission and the judiciary that this law has come as a result of certain old laws which are not really working well. You have some aspects of those laws either obsolete or are not being implemented. So what assurances can we have from the Lands Commission that they are going to make sure that every provision in this law is actually made to work? And then with the judiciary, cases that will be coming to them,
what assurances are we going to get that, for example, this issue of landguardism, we know there are some of the landguards who actually have their favorite judges and they run to them. We don't know what. No, please. Sorry, but this is Ghana and we need to understand what we're talking about. So please, what assurances can we have that I bring a case to court and I'll walk out level-headed that I have received justice?
Thank you. Thank you very much. But when a matter of crime is prepared by the police and taken to the court, you can't determine which judge will be handling it. Yes, please, your name and question.
Good afternoon. Please call me Okunyogobi and I'll respond for Asase. Yeah. Thank you. From TV Africa. Yeah. Please, with the Act, Section 12C, and I read, personality or through another person, unlawful use, force, or violence to prevent a person who has an interest in land from having access to the land or drive away the person with an interest in land from the land commit an offense. Let me end it here. Please, with this article, it talks about this land guard. I want to know from the traditional authorities that now people that call themselves, or we call them land guards, has turned into Asafwache. Now I want to know from the traditional authorities that under their administration, how many people form Asafwache? Because they come and they don't come as land guard anymore. They come as, oh, we are Asafu, so we are taking money. I want to know.
Thank you. Thank you very much. So we begin with the Lands Commission. We should. With the Lands Commission, Jeffrey Tete has a question for you. I'm sure you heard about that. Want some assurances that there will be implementation to the full.
Well, Lands Commission, we're always on the spot. We spent quite a bit of time in having the structures of land administration reformed. It took us almost 20 years of continuous work to get this Land Act passed. I must confess that that's not been easy. Therefore, you will not spend 20 years of your active life in trying to get an act which you do not intend to implement. The assurance will be given that as much as possible, we will try as much as possible as Lands Commission to ensure the full implementation of all aspects of this act. That assurance, I think, the Lands Commission, the board of the Lands Commission, as well as its management, will give to you on that. There was a question relating to the focus on urban lands instead of concentrating on rural or focus on rural areas. Yes, I agree to some extent. By the very nature of customary land tenure in this country, there is usually a reluctance in defining exactly what one owns where. Throughout the 18 years of the land administration project, it was quite difficult for us to whip up interest of people trying to register interest in land. The Office of Administrators to Land spent quite a bit of money in the Western, Central, and Brong-Ahafo regions in trying to get, in the parcel registration exercise, trying to get local farmers and the rest just getting boundaries of their parcels as a basis for getting their titles formalized. And there was quite a lot of reluctance, perhaps because of the sort of uncertain relationships they have with their tenures. It's a lot of work that is ahead of us. And the Act is not going to be based just on only urban areas. The intention actually is to scale up registration to cover the entire country. At the moment, registration in Ghana roughly is around 20%. And we need to scale it up if we want to get the advantages of scale that we are looking at. So I think together there is a lot of work ahead of us. Both the Lands Commission, academia, the professionals, as well as the civil society organizations. We will need to pool resources together to be able to do that. I must also sound a note of caution. We are a public agency and rely heavily on subventions from government. So the speed with which we will do the implementation is limited by what we get from our annual budgets. So please don't let us raise the expectations that within a year or two we can do it all, because we will need the resources to be able to do that. So I think that assurance can be given that there is a new vision within the Lands Commission which intends to ensure that the land administration sphere is improved upon. Thank you.
I don't know if that answer covers Naname's concern and request for functioning customary land secretariats, because we need them.
Yes, currently I think discussions are going on between the Lands Commission and the Office of Administrator of School Lands as to how to scale up. At the moment, we've established about 95 or so. Quite a number of them are not working. One, because of funding. Because the customary authorities themselves do not find economic value in the areas, and therefore they do not see the need to spend money for what they cannot get returns on. I think with time we will need to find ways of actually encouraging, but how to sustain them is something that we will have to work at. Thank you very much.
Thank you. Dr. Yeboah, there's a question from Jeffrey Tete, whether or not you actually stated emphatically or you were asking a question that the taxpayers' money will be used to compensate persons who may have been wronged by the omissions and commissions of land commission officers. So if you can respond to that. And then my Lord will answer Mabel's question on Section 283, and then Openyin Obuobi's question about the implications of Section 12C.
So that's relevant. And it's Section 196. But I'll step back into, to 194 and 5. And then, of course, I don't intend to give an emphatic or a definite answer. Our Lord Justices are here, they could always help. But it is something that is in the provision, and we need to really delve into what exactly that means. So Section 194 gives power for to the land registrar to rectify a land register. So when lands have been surveyed and they've been compiled into a land register, there is the power to the land registrar to rectify it if there are any identified errors, be it clerical or survey or whatever the source of error would be. 195 also says that the courts could also issue directive for a register to be rectified if some errors have been identified. Now, if you add 194 and 195, it leads you to the right of indemnity in 196. And what it says is that subject to this Act and the Limitation Act of 1972, NRCD 54, a person is entitled to be indemnified by the Republic if that person has suffered damage in consequence of being deprived of or prevented from acquiring land or an interest or a right in land by reason of A, rectification of the register, B, a mistake or an omission in the register which cannot be rectified under the Act, or which cannot be not ordered to be rectified under this Act, or an error in a certified copy or extracts from the register. So this is the provision. So there is the land register to be compiled from systematic registration and all that, but there is an opportunity for the land register to be rectified if there are errors. And what the law is saying, and let me use the words as captured in the Act. It's saying that if you've suffered any loss, you are entitled to be indemnified by the Republic. So I think this may need more legal interpretation and discussion. But indemnity could be either compensation or fine and replacement land or any other thing. Yeah, so that would be my response to that.
Thank you. My Lord, the two questions from Mabel on Section 283 and from Opening Obobi on Section 12C.
When we talk about the Section 12C, you come across the word a person. If it is being done by one person, then a person. But when we are interpreting, the Interpretation Act provides that when you come across a word singular, looking at the circumstance, it may mean plural, and plural also means singular. So even though the word a person has been used here, if you see about 20 or 30 people undertaking that act, a singular means plural. So the asafo, even though a person here, we will construe it as persons, and they will come within the context of land gas. Then when you come to Section 283, the transitional provision, the basic principles that are used to interpret transitional provision is that, first and foremost, it must be read as a whole. If you read it in pieces, you will mislead yourself. So first and foremost, it is read as a whole. So if it is read as a whole, then it tells you that where a step has been taken and it is before Land Commission, then if it were under any other enactment, then the current act should regulate it. But where it is under the State Lands Act and it has commenced, then it is the State Lands Act, even though repealed, it has been saved to address those situations. So that is the main difference between the two. So if you do not read it as a whole, you will know the actual meaning. So in effect, what it says is that all other laws, the 12 that have been repealed, assuming there is any matter pending to be considered by the Lands Commission, it will come under the Land Act. But if it were the State Lands Act, then it will be regulated by the State Lands Act, and not this one.
Thank you very much. We shall now have the remarks of the chairman for this occasion. That's the chairman of the national chairman of the Lands Commission, Stephen Ayesu, in team.
Okay, thank you. Needless to say, everybody needs lands or land to undertake almost every human activity. And that's not limited to Ghana, it's everywhere. This new law, in my opinion, has come to streamline a lot of gray areas in the laws governing land administration. It behoves on all of us to put in our best to ensure that this new law works. We've had 2 presentations. Justice Dennis Ajay of the Court of Appeal dwelt on the legal issues emanating from the law, issues like spousal rights. He addressed them. Re-entry provisions were also addressed, and a host of others. And I think through the questions and answers to other areas that his presentation couldn't address have also been filled in. Dr. Eric Yeboah also dwelt on, I don't want to repeat the built environment. He dwelt on the role of professionals in the implementation of this law. He also touched on ADR as the best option to address land disputes before seeking other redress. He touched on turnaround time, 14 days for searches and 30 days for land titles. Compensation in the wake of compulsory acquisitions, he touched on them as well. He was very much under pressure, so couldn't get into everything that he prepared to share with us. Pressure of time, actually. The questions and answers comments session also enabled him to fill in areas that he didn't maybe envisage before the presentation. All in all, I think everybody can take something home from here, even though we've not been able to exhaustively dissect the law here and now. But over time, this is just the beginning of the dissemination effort of the Act by the Lands Commission. Regional efforts will be made for the rest of the country, the rest of the populace, to get to know a whole lot of the law, about the law. So I would like to use this opportunity to thank the presenters and everybody who made it here at very short notice to come and participate. Especially we have our regional chairman, regional lands officers who have traveled far and wide from the 10, when I say Lands Commission, it's 10 regions for now in terms of regional representation of the Lands Commission around the country. We are working assiduously to get representation in the 6 newly created regions. But for now, it's the 10 regions that are administering land in 16 regions. So thank you all for participating in this symposium. And the Executive Secretary will very soon roll out the timetable for this type of symposium across the rest of the country. Thank you very much.
Thank you very much, Mr. Chairman. Please, I think our guests deserve another very, very loud round of applause. If you are catching a judge with questions from various parts and varied about land, and he is able to point to the specific provisions to answer them, that tells a lot. A lot of work has been done. Thank you so very much, Justice Dennis Ajay, and to also Dr. Yeboah for the expositions you have given us. I have personally benefited enormously from today's symposium. just a few things to note. Now, lunch is ready. And once we are done, we say the closing prayer. Then ministers, the Parliamentary Select Committee, representatives from the ministries, our special guests, members of the working group, as in the land bill, resource persons, we will all go to our left to take our packaged, sumptuous lunch. And then all of us participants will go downstairs and take ours as well. I am happy to let you know that the presentations will be emailed to all of us. If you have not left your email, please do so. And for further assurance to all, including Jeffrey Tete, that this sensitization will go on effectively, to inform you that there will be dissemination to utility agencies, that's roads, water, electricity, and telecom workers, sectors in the country, after this national symposium, aside the fact that there will be regional symposia as well. Then there will be the Northern Zone stakeholder engagements in Kumasi. There will be the National House of Chiefs engagement on this same law. There will be stakeholder engagement in Tamale. There will be the Southern Zone stakeholder engagement in Takoradi. MMDAs through local government ministry will also have your time. There will be interaction with built environment professional bodies. There will be interaction with the Ghana Bar Association. We are going to get a double portion. I can't wait for that. Then media engagements across the country as well, so that everybody will understand this law. Right, so I suppose that will be all for now. But in the meantime, members of the commission, you are supposed to wait on my right side briefly to meet with the executive. Without much ado, let's please welcome Surveyor Mabel Yemidi, the Acting Director of PVLMD, to give us the vote of thanks. After that, we will have Alhaji Abdul Hanan Idrisu to close us with a prayer.
Thank you. We thank God for this day. Today marks the dawn of a new day in the administration of lands in the country. On behalf of the Lands Commission, I say thank you to His Excellency, the Vice President, Alhaji Dr. Mahamudu Bawumia, for accepting to be the guest of honor and for the speech he delivered. I also thank our Honorable Minister for the program. He visited us last week and he said, Lands Commission, do something before you die. So today we have done something. And we hope you will all help us to bring a change to land administration in Ghana. The chairman of the Parliamentary Select Committee on Lands and the members have also supported us, and we are grateful. Nananom Nime, custodians of our lands, we are grateful for your presence. We work together as partners, and today when we called on you, you have not abandoned us. We thank you. Justice Sir Dennis Dominic Ajay, Surveyor Dr. Eric Yabua, Alaji Mahama Idrisu, my own boss. As resource persons, we have gained a lot from you today. We are thankful. Members of the Land Bill Working Group, it is your tireless efforts that have brought us this far. Day and night you worked, and today Ghana can boast of a new Land Act. Very few countries in Africa have such an act. God bless you for your efforts. Industry players, academia, professional bodies, security agencies, civil society, and faith-based organizations, we also thank you. Utility providers and the media, we are grateful. Our Honorable Lands Commission Chair, honorable members of the Commission, regional lands officers, management of Lands Commission, the event organizer, the media once again. The whole week you have engaged us. People have heard about us, and we say thank you. We hope anytime we call on all of us gathered here, you will support us so that before we die, we will make an impact in land administration. Thank you, and God bless us all.
Shall we have Abdul Hanan Idrisu?
Let's be in the mood of prayer. Please get seated. Bismillahirrahmanirrahim. In the name of Allah, the most merciful, the most beneficent. All praises be to Allah, the Lord of the worlds, the most merciful, the most beneficent, King of the day of judgment. You alone we worship, and you alone we ask for help. Guide us onto the righteous path, the path of those who you have blessed and not of those who have gone astray. Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. Ar-Rahmanir Rahim. Maliki Yawmiddin. Iyyaka na'budu wa iyyaka nasta'in. Ihdina as-siratal mustaqim. Siratal ladzina an'amta alayhim. Ghayril maghdubi alayhim waladdallin.
Thank you very much. So we are done, and thank you everyone. Remember that the guests, the ministers, and the rest of us, we are here to pick our package, and all participants, we go downstairs to pick our package. Thank you all so very much. Thank you.
National Lands Commission members, please, you go to my left.
is water, transparent and nearly colorless chemical substance which is the basic component of the Earth's streams, lakes and oceans and the liquid of most living organisms. Water is the most abundant liquid on Earth, covering more than 70% of the Earth's surface. It is impossible to exaggerate the importance of water to almost every process on Earth, from the life developments of the lowest germs to the influencing of continents. Water is the most familiar of all chemical compounds